Our last case this morning is Perry versus State of Michigan. This is a 15-minute mini oral argument on the application. Welcome, counsel. Mr. Cafferty, you may reserve some of your time if we do not use it up, and ask that you do your best to keep track of that time. And you have 2 minutes of a free fire zone if you wish.
Thank you, Your Honor. May it please the court, Michael Cafferty on behalf of the plaintiff appellant, Charles Dale Perry. I appreciate the fact that you saved the most exciting case for the last on your docket.
For the year.
This court's order of January 28, 2022, granting oral argument on the application poses the question of whether the new evidence was relevant to the legal basis that was cited for granting a new trial to Mr. Perry, specifically the prosecutorial misconduct and the ineffective assistance of counsel. I believe that that question needs to be answered in the affirmative. I think that the starting point for this court should be recognizing that merely because there was an error, such as some incompetence on the part of an attorney or some improper conduct on the part of a prosecutor, does not ipso facto mean that a convicted defendant gets a new trial. I know some of the justices here have served as trial judges, and they are aware, as are all of us, that no trial is error-free. There's always errors in any trial. Mistakes are made. That does not give somebody a right to a new trial. There's a statute that we cited in the brief, which is MCL 769.26, which addresses this. That statute says, and it applies to any court of the state, so it's not just a statute that applies in the trial court, it applies for the appellate courts. I believe the statute dates back to goes back to 1927, then it was changed a few times. And that says that when there's errors in a trial, you don't get a new trial from any court unless it, quote, shall affirmatively appear that the error complained of has resulted in a miscarriage of justice. And there's several Supreme Court cases that we cite in our brief that make similar references. So merely showing in this case that his attorney was unprepared would not have automatically granted or given Mr. Perry the right to get a new trial from the Court of Appeals.
But aren't we stuck with the fact that the Court of Appeals in this case, whether they should have or not, or whether we would agree or we would have, engaged in a harmlessness, analysis, they said that the prosecutorial misconduct in this case was incurably prejudicial. We're stuck with that, even though your client and defendant had also a new evidence or a claim of new evidence. Aren't we stuck with what the Court of Appeals decided then, or what the lower courts decided then?
Well, I understand what you're saying, but I think you have to take into account the totality of the circumstances. The Court of Appeals did grant relief in terms of the motion for remand was granted for the evidentiary hearing. The evidentiary hearing was held. There was very compelling evidence that came out in that evidentiary hearing showing that Mr. Perry was innocent of these charges. And that evidence was cited prominently by the Court of Appeals in its opinion. Now, we have to understand when the Court of Appeals was writing this opinion way back when, they weren't writing it with an eye toward a later WICA case that might be filed by Mr. Perry, but I think it's clear from their opinion that the new evidence played a role in their decision. They cite, in other words, why would they cite the new evidence, and why would they say at the end of the opinion, we're giving you a new trial so you can present this new evidence, if the new evidence had nothing to do with it? I would submit that if the new evidence that was generated on appeal, including from the remand order from the Court of Appeals, if that new evidence was not supportive of Mr. Perry's claim of innocence, we would really have nothing here. There's no conceivable way that he would have been granted a new trial merely because the prosecutor engaged in some invective or his attorney was unprepared.
Aren't you reading that into, reading behind what the Court of Appeals is saying? Because the Court of Appeals said the opposite. They said, we're not getting to the other issue because the prosecutorial misconduct is so prejudicial, that's a basis
Well,
to overturn the verdict. I mean,
they-
you're saying, well, they really wouldn't have done that if they also didn't believe in the strength of the new evidence, but that's not what they said.
Well, the prosecutorial misconduct was addressed in tandem with the ineffective assistance of counsel. On page 3 of the opinion, it says, it refers to the prosecutorial misconduct and says, we addressed them in tandem with his claim of ineffective assistance of counsel, because they both tied together. And the main part of the ineffective assistance of his counsel was that there were all these witnesses that Mr. Perry provided to his attorney that would show that this whole story that the complainant was pitching was just completely fabricated. This was his former girlfriend who lived with him a couple years before this incident, and he provided many witnesses, 10 or 12 witnesses that would support that, and his attorney tells him on the morning of the trial, I forgot to contact those witnesses, I haven't lined up any of those witnesses, you better fire me, and if you fire me, you can then get a new trial. And Judge Gilbert ended up telling Mr. Perry, if you fire your attorney, you're going to try the case on your own. So he kept this attorney. Now, part of the prosecutorial misconduct that was referred to in the Court of Appeals opinion giving Mr. Perry a new trial was that the prosecutor was badgering him and harassing him about the fact that, where are your corroborating witnesses? You say you lived with her for a period of time, that it was your former living girlfriend. Are you going to have witnesses? Where are your witnesses? And they said the Court of Appeals referred to him being repeatedly, harassed more or less about his lack of corroborating witnesses, which dovetails into the ineffective assistance of counsel, because the prosecutor was in a situation where no matter how Mr. Perry responded to those questions, the prosecutor wins, because if Mr. Perry reeled off the names of all the witnesses that would support his case, none of them had been lined up and perhaps not even listed by the attorney. So then the prosecutor could say in his closing argument, Mr. Perry said he had all these witnesses and he gave you 10 names. Guess what? We haven't heard from any of them. So, he's a liar. And that was a significant part. It wasn't the only part of the prosecutorial misconduct, but that was a significant part of it, which dovetailed with the ineffective assistance of counsel. And the fact that the Court of Appeals granted the motion to remand after Mr. Perry's appellate attorney submitted numerous affidavits from witnesses providing this new evidence of the fact that Mr. Perry had lived with this woman. And in our appendix at page 23, there's the affidavit of Teresa Rice, who said, I was there many times at the house, they lived together, they shared a bedroom. At page 25 of our appendix, Timothy Anderson, another witness. And based on all this new evidence, the Court of Appeals says, you get a hearing, a remand hearing. He had a remand hearing. These witnesses testified. They provide overwhelming new evidence of Mr. Perry's innocence, which was cited prominently in the Court of Appeals opinion. And I would submit that the Court of Appeals is not, as are all of the appellate justices and judges of the state, they're not in the practice of citing things or putting things in opinions that are just mere surplusage or irrelevant. They specifically talked in the opinion about the new evidence. On page 2, the evidentiary hearings were held in which 2 witnesses testified that they had heard complainant acknowledge in July 1991 that the defendant had not raped her. 2 other witnesses testified that complainant had lived with defendant in 1988. Why would they be highlighting this evidence if it was irrelevant to their determination? I would submit that without the new evidence...
The hearing you're referring to is the Ginther hearing?
The Ginther hearing, yes, Your Honor.
The Ginther hearing is a remand for determination whether there was ineffective assistance of counsel.
Yes.
And by its nature, if there's ineffective assistance, there is evidence out there that the attorney should have focused on but didn't.
Yes.
And we don't need to get into whether that constitutes newly discovered evidence or not, but the fact remains it was based upon a finding of ineffective assistance. Doesn't your case fall squarely within the parameters of the Tomaszek decision, in which Justice McCormack identified the situation you now find yourself in, and concluded that was a fix for the legislature?
No, with all due respect, Your Honor, I do not think that this is similar. I know that the Court of Appeals said that this was identical to Tomasic, and the state in its brief claims it's identical to Tomasic, but I think this case is highly distinguishable from Tomasic. I know Tomasic has kind of a mind-boggling procedural history, but when you get through all that procedural history, there was really no new evidence issue in Tomasic, because in Tomasic, the quote, new evidence that was being claimed in that case was merely cumulative. It was the complaining person in that case went by the initials TJ, and the evidence that was, the new evidence was counseling records showing basically that TJ was a liar. That was the new evidence in that case. And it had nothing to do with any relief being granted, because it was determined on the Court of Appeals that that new evidence was merely cumulative of overwhelming evidence that was admitted at trial of this TJ kid being a liar. So they said, this little speck of new evidence has nothing to do with it. It's merely cumulative of all the other evidence. So that didn't play any role in Tomasic getting a new trial. The reason Tomasic got a new trial was because the court determined that it was improper to admit his interrogation record, or the video or the record of his interrogation by the police. That's why he got a new trial. It had nothing to do with, the only new evidence in that case was the cumulative new evidence, which is totally different from what we have here.
So if there is an ineffective assistance claim that's premised on the failure to bring evidence that should have been brought, is that always going to be a WICA claim?
It's not always going to be a WICA claim. I mean, there could be situations where the new evidence is cumulative of other evidence.
But if it's cumulative of other evidence, then there's really no ineffective assistance, is there? Because counsel didn't do anything wrong if it's cumulative.
Right, that's true. And in this case, there would be no ineffective assistance of counsel if it wasn't for the fact that the new evidence was overwhelmingly supportive of Mr. Perry.
But the question is, if we accept your position, would every ineffective assistance claim that is premised upon the failure to bring evidence now turn into a WICA claim?
Well, in that narrow circumstance, it may be the case. If the new evidence is overwhelmingly exculpatory and the attorney failed to produce that evidence at the trial, and that new evidence then resulted in an acquittal, then I think one could say that the new evidence resulted in, and that's the language of the statute, resulted in, which I'll note is much broader than like the proximate cause standard from the Robinson versus City of Detroit case. I think resulted in is a little bit broader. I think in that situation that you're talking about, I think one could logically argue that the new evidence resulted in him getting relief and him being acquitted at trial. So I think under that narrow circumstance.
Just so I understand, your limiting principle would be, it's not enough that you get a new trial for ineffective assistance. You must then win on the basis of the evidence you didn't put in the first trial.
Yes.
Which then takes me to the question, was it really new evidence or old evidence that should have been presented in the first trial?
Well, under this court's ruling in Maples, I mean, I think it's clearly new evidence. Like in this case, even though Mr. Perry knew about all these witnesses that could exonerate him, so it wasn't new to him, but under the definition of WICA, it's new evidence because it wasn't used, in the trial court proceedings. And again, I would just say that both the prosecutorial misconduct and the ineffective assistance claims would have really been, to use the parlance of our time, nothing burgers if it wasn't for all this new evidence that was produced on appeal that showed that this gentleman was innocent. This falls right into what WICA was intended to do. We're talking about an innocent guy who spent parts of 5 calendar years in prison during the prime of his life for a crime that he didn't commit, and his incompetent lawyer failed to produce all the evidence that should have been produced at the first trial. This falls squarely into what WICA was intended to do.
Counsel, let me just try and understand a little. I think Justice Zahra's question about ineffective assistance claims where an attorney has not uncovered or discovered evidence of innocence is a good one. But in this case, it was the prosecutorial misconduct claim, not the ineffective assistance claim, that led to the reversal, correct?
Well, the Court of Appeals opinion says they're addressing it in tandem. They took it together. Page 3 of the Court of Appeals opinion, it says they're addressing the prosecutorial misconduct in tandem with the ineffective assistance, because they did kind of dovetail together.
Well, they were addressing them, but it was the reason for the relief was the prosecutorial misconduct. Look,
Yeah,
I think technically, I think I understand what you're saying, but let me just push you a little bit. You could imagine a case of prosecutorial misconduct where the prosecutor suppressed evidence of innocence, and I bet the Attorney General wouldn't fight that case if there was a case where prosecutorial misconduct, the specific claim of prosecutorial misconduct involved suppressing evidence of innocence. I bet the Attorney General, will ask him when he stands up, but I bet they would agree that that particular claim, even though it's not a Crest claim, it's not a new evidence claim, it resulted in the reversal. But here we have to take the leap that I think Justice Kavanaugh was asking you about, which probably is correct, that the evidence of innocence was important to the relief granted, because without it, it would have been a harmless error case like many other, like you said, most trials are imperfect.
Yes.
But we have to fill in the blanks here, right? To be able to say that the evidence of innocence resulted in the reversal, it has to be through this harmless error lens. Is that right?
Well, yes and no. I don't think you have to use a crystal ball to figure out what the Court of Appeals was doing here. They cited the new evidence, and they said at the end, our disposition of this case allows you to present that new evidence at trial. So I think.
But they never said because of all this evidence of innocence, we find that this error was not harmless, right? So we have to fill in some blanks.
Yes, you have to fill in some blanks.
So here's the question I have for you. The legislature had to draw some lines because they, like they always do, and some of them can end up being a little bit blunt or a little bit random. But it might well have been that they assumed that in a case of prosecutorial misconduct or a case of ineffective assistance, that a wrongfully convicted litigant would have other ways to get compensation. They could, sue the prosecutor's office, sue their lawyer. I happen to know in practice none of that ever happens and none of that ever works, but that doesn't mean that the legislature didn't think this was one way of, line drawing. What's your answer to that? I wish we had a legislator on the court who could help us sort this out.
Well, I think that we have to start with, the starting point should be this is a remedial statute, so we should interpret the language broadly, and the resulted in language, I think, is broad enough, because they knew, like from the Robinson case, they knew they could have said the proximate cause or something. They didn't say the only reason that you get a new trial is because of this. They said resulted in, the new evidence resulted in, and I think that should be interpreted broadly enough to avoid an unfair result. Because keep in mind, the Court of Appeals in this case, what they said is basically we recognize we're reaching a very unfair result here. I don't think you need to reach it. I think within the confines of the way the statute is written, the resulted in language, I think it's broad enough to encompass a situation like this, because frankly, I think we all know that without this new evidence that was cited by the Court of Appeals, and which the Court of Appeals specifically said we're resolving this case in a manner that lets you present it, without that new evidence, this would have been a nothing burger. If the witnesses that were not contacted didn't have any helpful information to Mr. Perry, then why would it have been improper for the prosecutor to have harangued Mr. Perry about not having corroborating witnesses? None of this would have made sense but for the new evidence.
It's a really good answer. I appreciate it.
Thank you.
Thank you.
I see I'm in overtime here, so I will sit down.
Thank you.
May it please the court, Eric Restuccia appearing on behalf of the state of Michigan. With me at council table is Gallant Fish from the Attorney General's office, and he's one of the attorneys assigned to our Wrongful Imprisonment Compensation Act unit, so he's handling these cases on a day-to-day basis. This is the fourth Wrongful Imprisonment Compensation Act case that this court has reviewed. As in those other cases, the state doesn't view this as traditional litigation, that we're really trying to attempt to apply the statute as the legislature has given it to us. So, if the state's misinterpreting the law, we welcome this court's clarification. In my view, these are very important cases. I mean, there's money at stake, but that's not really what it's about in some sense. I mean, this is a statement about innocence. Now, the legislature, though, created parameters. And so the department's not at liberty just to grant relief to everyone who it may think is innocent, but it has to work through the statute. And so with that, I want to make 3 points this afternoon. The first is the statutory language is unambiguous that the new evidence of innocence must result in the setting aside of the conviction. That's the first point. The second point is that Mr. Perry's conviction was set aside exclusively based on prosecutorial misconduct and the ineffective assistance of counsel related to the prosecutorial misconduct. The new evidence of the 5 witnesses identified at the Ginther hearing played no role whatsoever in the grant of relief on the claim of prosecutorial misconduct and the ineffective assistance. And that's why in Section 2 it makes reference to those witnesses, because they were never addressed in the merits analysis. And it says, with respect to the remaining witnesses, they may testify at trial because we're not going to address the moot claims. And so the new evidence claim was mooted by the prosecutorial misconduct decision. In fact, if you look at the analysis, the prosecutorial misconduct prejudice analysis talked about new evidence that had been introduced by the prosecution inappropriately. The 2 affidavits and the cross-examination which are brought in evidence. That was the basis for relief. It was a prosecutorial misconduct claim alone. The third point that I wish to address, whether there's any questions as well, is the University of Michigan amicus had advanced an argument that there could be new evidence that was not presented to the trier of fact based on the testimony of the Perry's counsel at the Ginther hearing, that there was no strategic basis for the objection. But that doesn't constitute new evidence under 1755(1)(c) because it doesn't relate to guilt or innocence, and so it doesn't meet the parameters of the statute.
So can I go back to just, do you agree that the evidence of innocence played some role in the harmlessness analysis for granting relief?
No, I don't. And in fact,
Is prosecutorial misconduct ever structural error?
I think the point you made earlier about the prosecutorial misconduct could give rise to a claim under the WICA statute, I think is right.
Oh, of course, that's an easy case.
Okay.
I want to ask the harder case.
Okay.
I knew you'd agree with that,
All
of
right,
course.
well.
I mean, you're not going to fight that case.
Sure.
But if a prosecutor actually suppresses evidence of innocence, come on, right, put that aside. In this case, though, just like let's use this harder case, where I think I agree with you, it's clear that the Court of Appeals didn't say, it didn't even say anything about harmlessness. But prosecutorial misconduct is not a structural error claim, right? So they did a harmlessness analysis, correct?
Well, the prejudice analysis, I mean, in a way, this is a historical inquiry, right? I mean, I think if you look at a 3-part test, and so we're kind of left with the text of what the court said.
Yeah.
Like citing the 769-26, I think that's true, that's out there. And I think there is a miscarriage of justice according to this court, the court's analysis back in 1994, but it zeroed in on, because it lists 9 instances of prosecutorial misconduct. And then when it does its analysis.
It sounds like you agree with me that prosecutorial misconduct is not structural error. I appreciate
Well, I'm trying to
go
think
on
of the circumstance in which it would constitute structural error, and I haven't, but I'm not sure.
I can't think of one, and I have never found one. You've been at this about as long as I have, but
Yeah.
if neither of us can think of one,
I don't have one offhand, but there was a prejudice analysis. You are exactly right. They didn't say it was per se because of the. Go ahead. Continue with your
No.
question. I agree.
If it's not structural error, then we have to assume that there's a harmlessness analysis, and I think the court, didn't do it nicely, didn't do it elegantly, didn't do it in a way that we could actually track it. But if the court, as a result of the evidence of innocence, found that what in any other case probably would have been found to be harmless error, found it to be harmful error, why isn't that resulting in?
Because there was no determination that those 5 witnesses and the failure to call them was error. There was no analysis on it. So when they're doing the prosecutorial misconduct analysis, they didn't consider any of the exculpatory witnesses who were presented at the Ginther hearing. They weren't considered, nor should they have been until they do an evaluation of the quality of that witnesses, but of course it's not relevant for the prosecutorial misconduct. The only way the prosecutorial misconduct could give rise to an error would be the prosecutor would have to have known about those witnesses and sandbagged. But that's the People versus Rich case, where there can be prejudice arising from the prosecution's awareness of other witnesses. But the prosecutor had no awareness of those
No,
witnesses.
I agree, but you agreed with me that that prosecutorial misconduct is not a structural error claim. So they had to do some harmlessness analysis, and that had to include.
They did do a prejudice analysis. And what they did is, and the way the analysis runs, and the way they found prejudice without considering any of these other 5 witnesses, they said this. In a case in which is one person's witness against another, credibility is the crucial consideration. And where the prosecution is bringing in what it calls other evidence, which is non-record, the 2 affidavits and the 2 other things that happen on cross-examination, that fundamentally affects the fairness of the trial and rendered it prejudicial. So that's the completeness of the analysis.
So the prejudice analysis was sufficient without consideration of the evidence of innocence. It was prejudicial even apart from.
In fact, if you look at the one place where the court, in its analysis on page 8 of the opinion, I think it's 50A or 50A would actually, when they actually get to it.
My last argument is getting to talk to you about something really interesting. So keep at it.
Well, I have to say, it's an honor to have the opportunity to be at your last argument, frankly. But if you look at 50A, the way the court does actually make reference to this, the challenge to produce corroborative witnesses, they make reference to it in the analysis. But then they say, they introduced it by being mockery and ridicule. That's how it's introduced in that paragraph. And they've already said it's prejudicial before they even get to this piece. And when it was introduced in the listing of instances of error, this was the shifting of the burden. And then they go on to say, while perhaps being susceptible of a cure by a timely objection. This is a very small point, right? They're not talking about those 5 witnesses, because it would never be the case where you had 2 witnesses who can say you're totally innocent, and then you're talking about them, well, that may be susceptible of cure by a timely objection. Questionable fairness. It's not of questionable fairness. If he had known that there were 2 witnesses or all these other people, and he comes in and says, where are they? That would be an outrage, right? I mean, this analysis doesn't, it's a historical analysis. We're trying to be as honest as we can.
Yeah.
This opinion did not address any of those witnesses. Didn't consider them, like for example, part of the Ginther hearing testimony was Perry's counsel said 2 of the witnesses were not, or some of the witnesses were not credible. I don't know which ones are or which ones weren't, because there's no analysis. All of the setup.
Also a good answer. Great. Others have questions, right?
Sure.
I have more, but you go ahead.
No, go ahead.
It
It is, after all, your last
Thank you. So the other thing I keep trying to figure out is what, I get that the legislature has to draw lines, and, you can't, and it might be a good one to just, eliminate cases where people can sue other people. At least that was what I was coming up with as a reason why, maybe when there are other claims that somebody gets relief on, even if it turns out they're innocent, this is not going to, don't go to the WICA pot. Go to your attorney's malpractice insurance, go to the county's, malpractice insurance and get compensated. And maybe that's what they were thinking. On the other hand, the practical reality is, that for the most part, prosecutorial immunity means you're never going to get relief that way. And I think the legislature probably knew that as well. So why would this line drawing make much sense? I mean, as you and I both know, in most cases where there is proven evidence of innocence, there is almost always overlapping ineffective assistance and or prosecutorial or police misconduct. Otherwise, the person would have been acquitted, right? I mean, they're almost always overlapping. So why would it make sense? This is not really a lawyer question.
I can answer that. I'm ready to answer this, because in a way it's funny, because this actually has practical value. Because if you look at the 1755-1C, it lays out the 3 elements. The new evidence demonstrates the plaintiff did not perpetrate the crime, results in the reversal or vacation of the conviction, and results in either dismissal or acquittal. And the question is, why the 2nd and 3rd elements? If I'm no longer in prison and I can show I'm innocent, why are you going to require that same innocence also show that it was the basis of the vacation of the conviction? Well, what it does for us in the office in a very real way is that there's already been a vetting of the evidence. There's been a judicial vetting. There's already been a court that's spoken about. In fact, the very thing that didn't happen here is the thing that would happen if the court had ruled on the new evidence claim. In fact, the only court that did rule on those 5 witnesses was Alice Gilbert, and she denied relief. Now, she didn't issue an opinion, why, but the only person that evaluated judicially rejected the claim. Where that goes is, when someone's going to have a basis for relief and it comes to our office, we've already had some kind of vetting judicially of the new evidence. Because
I might not have been clear in my question. I meant to say, like, if in a case where everybody agrees that somebody is innocent, but there was also ineffective assistance and also prosecutorial misconduct, which often is the case. It's rarely the case that there's evidence of innocence that, you know, a good lawyer couldn't have found or a prosecutor couldn't have found. And it just so happens that those two other claims, or one of those other claims, is the easiest one for a court to reach, because, you know, new evidence is funky and it's all, like, I mean, it's much easier to write an opinion saying your lawyer was constitutionally ineffective. Why would the legislature say that person who had wrong done to him by everybody, his lawyer, his prosecutor, the police, and, you know, and the rest of the world, you don't get relief, only this other person does? Wow.
Well, premised on your question, which you said there could be multiple claims. One is the new evidence claim, or that presents some new evidence. Sometimes they're the hardest ones to reach. But you also said everyone knows that the new evidence claim would be the one in which the person's entitled to relief. But that premise in the question is the very thing I was trying to address when I first answered it, and I don't feel like I but it's the idea that if there has been no judicial review of that new evidence, or the claim of the things that, because I think there can be an effective assistance of counsel claim that gives rise to a WICA claim. If I have an alibi witness, and I didn't call that alibi witness, right? Or the kind of thing here, if there had been a ruling on ineffective assistance of counsel for failing to call these 5 witnesses, but in the real probability analysis under Strickland, they would have talked about those witnesses and their value and why he found some not to be credible or whatever. There would have been, but that vetting would have occurred. And so when you start with your question and said everyone agrees, well, that's the very thing, is that we get these claims. In fact, one of the things I was going to say to the court is if you really want to drill in on this second element of 1755-1C, it's Mr. Fish's case, pending before this case, Maples, in which the Michigan Court of Appeals, Tom Cameron, in his opinion, said this is really difficult because that was a speedy trial claim. And anyone knows about speedy trial, it has the 4 factors, and this was the 4th factor. And the question was, he said it was very hard to penetrate, and he says they have a burden of clear and convincing evidence. I mean, there's a case calling out for further direction. We have a hard time with that kind of case where there actually was some analysis. What's happened here is even the claim that there was a harmless error piece to it, there wasn't. It didn't factor in. It was not relevant at all. There was a basis for the remand.
But I get it. I see your point. At least in those other cases where ineffective assistance or prosecutorial misconduct is considered and they explicitly consider the evidence of innocence in the harmlessness analysis, then you have some basis for saying it resulted in. But it sure seems to stink for this guy, right? Because if he hadn't had this other misconduct on top of the misconduct that, you know, or the ineffective assistance, he would have been entitled to relief.
But I think
wow, like the more things that go wrong, the less relief you get.
But I don't think it's lost. It's out there. I mean, obviously, you know, Judge Godola and Markey flagged this in their opinion. You flagged it in the concurrence in Thomasik, and who knows, there may be a legislative fix in the works that talks about, makes this retroactive for people who have new evidence claims. That could happen, you know. But that's what they're, in a way, we're stewards.
Yeah.
We don't have the liberty of saying, well, boy, look at these other 5 witnesses, and let's drill. We haven't done that, and we haven't had to yet. But if we're trying to be honest with this statute, this was not the basis for relief. This was just on all 4s the Thomasik. And so he's just left in a position with the very thing you were talking about. What about the new evidence plusers? How could they have been left out? Did the legislature contemplate this? No. Did they or not? I don't know, but I do know that that element is present and hasn't been met. So for our department, we're left with, he doesn't meet that element, we move to dismiss. And we've had a lot of these cases. There have been 109 filed. I think 65 have gotten relief. 37 have been dismissed. I mean, there were some that were dismissed, you know, like sufficiency. Those claims got kicked out. There were 3 sufficiency cases. Now, should they have been denied? They don't meet the statute.
Yeah. I've hogged it. Go.
I'm sorry.
Sorry.
So in the end, I mean, I'm honest when I say, I mean, if we're missing something, let us know, because these are very important cases, and we're trying to get it right. Now, my honest assessment is that this played no role in the grant of relief. I think the Court of Appeals, in fact, Judge Shapiro, you know what he suggested in his concurrence below, and he he agreed with that he's not entitled to relief. He said we should reach the new evidence claim now, 26 years later, because that had never been evaluated. And he was trying to think creatively, because the legislative scheme doesn't allow for relief, because strictly speaking, that inquiry is a historical one, and it wasn't the basis for relief. And that's why, for good or ill, he is not entitled to relief under the statute. Thank you very much. Thank you, Justice.
Thank you
Thank you,
both,
Justice
and the
McCormack.
case will be submitted, and the court will stand adjourned.